Hi, I'm Weston LaBar. Welcome to another episode of People on the Move, a Cargomatic podcast. I'm joined today by Jon Eisen, Executive Director of the Intermodal Motor Carrier Conference of the American Trucking Association. Jon, thanks for joining us again.
Glad to be here, Weston. Appreciate you having me.
Well, it's always good to have the heavyweight champion of advocacy in the trucking industry. And since you've joined, there's been no shortage of wins. And one of the biggest ones that's been highlighted is the chassis choice decision that's come down, and obviously what that means to the industry. There's been a lot of questions. Does it apply to multiple districts? Does it apply everywhere? What are the next steps? How do we view this? And so felt it was really appropriate between chassis choice and then our later topic, detention and demurrage billing rule, to get you on and help educate the folks out there as to what's going on. And so with that, I hand it over to you to start on chassis choice. What are the big things people need to understand that this litigation means, doesn't mean, and what are next steps?
Sure. Well, let me give you a little bit of background. Let's start with kind of where all this came from and what's happened and what got us to this point. In 2020, the Intermodal Motor Carriers Conference filed a complaint at the Federal Maritime Commission against the Ocean Carrier Equipment Management Association, OCEMA, CC Consolidated Chassis Management Company, and 11 different ocean shipping lines, alleging that they have violated the Shipping Act by imposing and engaging in unjust and unreasonable regulations and practices by denying motor carriers the ability to use the chassis provider of their choice for merchant haulage moves. And that's where the chassis choice name comes from. The complaint was filed in 2020. In early 2023, the administrative law judge at the FMC issued her initial decision and granted IMCC's motion for summary judgment in part, but certainly in our view on all of the key issues. And she essentially ruled that ocean carrier policies and practices that prohibit a motor carrier from using the chassis provider of their choice for merchant haulage was a violation of the Shipping Act. She did allow ocean carriers to designate a default provider, but if a motor carrier chose a particular provider, she said they could not be denied that ability to do so. The ocean carriers appealed that decision, and earlier this year, in mid-February, the full Federal Maritime Commission affirmed the administrative law judge's decision in its entirety on a 4-1 vote. One of the commissioners did dissent, though he did not really provide any reason for why he dissented. So we don't really know the answer to that. As to what the decision actually said, the key parts are, first, that the FMC has jurisdiction in this area. This was something the ocean carriers disputed, but the ruling from both the judge and the FMC makes clear that the commission does have jurisdiction both at maritime ports and at inland rail facilities for international cargo traveling on the through bill of lading. And that will come up again as well in the detention demurrage invoice bill rule when we discuss that later. The Shipping Act essentially states that common carriers have responsibility to establish, observe, and enforce just and reasonable regulations around the receiving, handling, storage, and delivery of property, and that their involvement and contracts around chassis with chassis providers fit this bill. She ruled that the ocean carriers cannot engage in activities or include policies in their contracts with intermodal equipment providers, which require motor carriers to use a particular chassis provider for merchant haulage container movements. They cannot dictate which IEP a motor carrier uses in merchant haulage when the motor carrier is paying for the chassis. She also applied this to the pool of pools in LA Long Beach, which is obviously an interoperable pool, so you can use a chassis for any container, but the billing is done by the provider of the ocean carrier's choice. So the motor carrier does not have choice in that particular construction. And then finally, also that ocean carrier contracts linking carrier haulage and merchant haulage are a violation of the Shipping Act. Ocean carriers have negotiated contracts with the IEPs linking carrier haulage volume with merchant haulage volume to provide lower prices for steamship lines. But because motor carriers can't choose their chassis providers in these contracts, ocean carriers are getting greater volume discounts because they're lumping those two, both carrier and merchant haulage together, using that merchant haulage volume as captive volume. So that's a violation of the Shipping Act as well. So those are the major rulings that came down in the case. And the administrative law judge issued that decision about a year ago, and then the full FMC has now affirmed it. As part of the decision, the judge issued and the FMC affirmed cease and desist orders regarding all of these practices in the 4 locations that were covered in the case. Now, we narrowed it down to 4 particular locations to at least make discovery a reasonable process. If we had to do discovery across every port in the country, that would have been impossible. So we narrowed it down to LA, Long Beach, Savannah, Memphis, and Chicago, and those locations were ordered to be found to be representative, and so that's what we limited to. And so the ruling by the FMC affirmed the judge's decision and issued cease and desist orders regarding all of those practices in these 4 different locations. So that's where we stand right now, and we can certainly continue to. There's been a subsequent action. I can kind of outline that as we go through it, but I'll stop there and let you ask any questions.
Fantastic. So to clarify, for the motor carrier, when it's an international shipment, whether it's at a marine port or an inland port on the through bill of lading, i.e., if I'm paying for the chassis, I get to choose what chassis I want to use in the 4 locations that have been outlined, which are Los Angeles and Long Beach, Savannah, Memphis, and Chicago. That's the 30,000-foot bullet point summary. And then from there are the questions about where is next, or does this become broadly applicable? Obviously, Judge Worth had made some indications about broad applicability following the FMC review, where they indicated that this should be uniform everywhere as opposed to in those 4 locations. But it seems like that's the next big clarifying position that we're waiting for in this case. Is this broadly applied, or is it going to maintain in just those 4 locations? And part of it may be as motor carriers challenge whether or not chassis choice applies in those different jurisdictions, the legal process, if you will continue to then look at those locations, and eventually there will be some sort of ruling whether it's location by location or broadly applicable. Is that correct?
I think that is correct. The cease and desist orders apply solely to those 4 locations because they were the 4 locations involved in the litigation and for which discovery was done. But as you say, this is essentially, in some respects, in our view, a national order. The FMC at least views it that way, that subsequent activity to deny motor carriers chassis choice by ocean carriers, I think the FMC would view as a violation. And certainly Rebecca Dye was testifying in her confirmation hearing before the Senate Commerce Committee probably 6 weeks ago or so now, and kind of outlined her view that such behavior going forward would be a violation. But I think, as you kind of outlined, that might be the subject of subsequent legal action were a motor carrier to be denied choice. That might have to wind up going before the FMC in a subsequent location. Though there is now, we are continuing with the legal process. The second part of the FMC's order was to remand the case back to the ALJ for final disposition of the case. So there were some issues that were still outstanding. So the process is still going on. We're still in the case at the administrative law judge level. We, along with the respondents, the ocean carriers, filed a joint status report last week outlining where each of the parties believe this case should go. In our view, we believe that certainly that there is sufficient evidence for these cease and desist orders to be given nationwide, but the judge will have to decide on that. We also asked the judge to require the ocean carriers to submit a compliance report so we can understand how they are going to comply with these orders. We will see how the judge rules on all of that. And one other small point, the ocean carriers did file a petition for reconsideration at the FMC, asking the FMC to reconsider their decision. In our view, there's nothing new there, but it was filed. So just to update you on that.
That's procedural in many cases. Just
in our view, yes.
Can you rethink your decision, right?
Yes.
And then again, just saying it in a different way, this does not apply to carrier haulage moves and or situations where somebody else is paying for the equipment, right? So if your customer says, please use a pooled chassis and they're going to pay for it, they obviously can make that request of you. Or if you're doing a door move for an ocean carrier, they can dictate the chassis. But it's when you're doing the move in merchant haulage and you're paying for the chassis, it's your choice. That's what chassis choice means.
That's correct. That's correct.
Fantastic. And then the other question that I would have, and this one may be less clear, but as you mentioned, on a through bill of lading at inland ports, it applies as well. One of the issues that sometimes pop up, the newer rail terminals, as you know, are grounded by and large, but some of the older ones are still wheeled operations, and they don't always provide flip services within the amount of free time. Obviously, I think there's some context that's going to need to come from what that looks like. But what happens in that situation where you're doing a merchant haulage move, you're paying for the chassis, you bring it, and the rail says, we're not going to provide flip services. And I think this will probably be a great segue into the next one, and we're going to charge demurrage for not picking it up, even though we wouldn't let you take it.
Well, I think that's, there is some gray area there. The FMC very clearly, in applying these cease and desist orders to Memphis and Chicago, does envision that railheads are included in their jurisdiction. International cargo at railheads is included in their jurisdiction. But I think that's part of why we've asked for a compliance report from the ocean carriers. We want to see exactly how they're going to handle that, because in our view, clearly they're already in violation of the Shipping Act. We want to see how they intend to come into compliance. And then we will decide on next steps as we have a better understanding of exactly how they're going to approach that. So that's, I think, clearly it's encompassed in the scope of the ruling, but exactly how it will work in practice, I think, is still to come.
That's well said, and we'll stay tuned for more updates on that. The other big news recently, obviously, is the final detention and demurrage billing rule that the FMC issued. This has been part of a much larger Ocean Shipping Reform Act process that's been going on throughout Congress, the Federal Maritime Commission, for several years now. It really got hot and heavy, as we all know, during the pandemic, to try to alleviate and solve for some of the systemic issues that really the supply chain ecosystem was seeing. And more frequently, it was the motor carrier and the shipper that were getting heavy-handed bills, if you will, outside of what was a well-defined process without much recourse, I guess, would be the argument that was being made by BCOs and truckers. Talk a little bit about what the final rule on detention and demurrage billing means. There's obviously been some key changes around billing timelines, about information necessary, when you can charge, when you can't charge. Talk a little bit about this, because I believe the clarity in and of itself is a win for the motor carrier community and for the shipping community, because in many cases there was ambiguity in this process that created a lot of opportunities for dispute processes, which were not in and of themselves streamlined or efficient either.
Yeah, I think that's right, and we were very pleased with the final rule and the process. The final rule was issued just a few weeks ago, and it was required by the Ocean Shipping Reform Act to build upon the initial interpretive rule on detention and demurrage. The Ocean Shipping Reform Act required a new rule to further clarify reasonable rules and practices related to the assessment of detention and demurrage, including, and this was critically important from our perspective on the motor carrier side, it required the agency to include in the rulemaking a determination of which parties may be appropriately billed for any detention and demurrage or other similar per container charges. And the rule kind of outlines the terms and conditions for detention and demurrage invoices, including who can receive them, what they must contain, and then, as you kind of said, the timeframes for issuance and disputes. So in terms of the content of the rule, first it outlines what is a properly issued invoice and defines it as a detention and demurrage invoice issued by a billing party to, number one, the person for whose account the billing party provided ocean transportation or storage of cargo, and who contracted with the billing party for the ocean transportation or storage of cargo, or number two, the consignee. So the bill can only go to the person who's actually contracted for the ocean transportation or storage of that cargo. And it cannot be issued to anybody else. It can only one detention and demurrage issued, and it has to go to one of those two parties, the party that contracted for the ocean transportation or the consignee. In our view, that makes it pretty clear that it has to go to the shipper in these cases. And so, from our perspective, we think that's the company that contracted with the ocean carrier, understands the terms and conditions under which the container was shipped, and has the relationship with the ocean carrier. And I think that's an important part of this rule. It works on contractual relationships, and parties have a greater responsibility and a better incentive to work more closely with their customers going forward. And so we believe that in the long term, this is going to hopefully create a smoother billing process with less errors. Doesn't mean that motor carriers will be out of the business of taking screenshots and assisting their customers in understanding when these bills are correct and when they are not. But motor carriers will now be working with their customers directly instead of with ocean carriers. And we think that's going to be a big improvement for the supply chain. It addresses a couple of other issues. As you mentioned, it talks about timeframes. Invoices must be issued within 30 days of the date the charge was last incurred. And if not, the billed party is not required to pay. It has a little more leeway for NVOCCs that receive a bill from an ocean carrier, gives them 30 days from the date it received the invoice to then send it on to the billing party. The billing party, so the ocean carriers must allow 30 days to require for requests to mitigate, refund, or waive the charge. And if that request is received, the billing party must attempt to resolve the request within 30 days or a later date if agreed upon by both parties. That was actually a change from the initial proposed rule, which essentially said that if they didn't agree upon a relief or it wasn't or was not satisfied, they didn't have to pay the invoice. But that provision was taken out. So it creates much tighter time, essentially 30 days in all cases, which does conflict with some current practices, and I think we'll see some changes in some areas. And then there's one other part it implements. It implements the requirements of the Ocean Shipping Reform Act regarding some of the data points that have to be included on the invoice. It also actually requires a few additional points of information, but for the moment, that portion of the rule has been delayed, so that portion will not take effect. The overall rule itself takes effect on May 28th, so in just a couple of months.
Yeah, and when you talk about the first point of that, the thought process was always there's a direct contract between the BCO/consignee and the shipping line or the equipment owner, the IEP, and thus they have more of a commercial relationship where they can negotiate the fairness of the billing, right, and of these fines and fees, which creates more fair dealings between the two parties because they actually have a contract and they have stipulated requirements within that contract. But that all said, as you said, the motor carrier is not going to get out of it completely. At a very minimum, you're going to need to provide backup as to when you can't return something and what the different circumstances around the potential for receiving, for lack of better terms, an unallowable bill, right? You have to be able to provide that backup at a minimum. But in some cases, and I know some motor carriers are starting to do this and or gear up for this as a practice, they may be the agent of their customer if they agree to, and their customer nominates them to do so, to essentially handle these on their behalf. But the big thing there is that unless the motor carrier has an agreement, a commercial agreement, a contract with the ocean carrier on a lane, such as a door move or something along those lines, the motor carrier cannot be shut out from doing transactions with that line due to per diem billing. Is that correct?
Well, they generally can't receive the bill, and so they would not be the responsible party for paying that bill. And as a result, the ocean carrier would have nothing to shut them out on, because they would not be the ones in arrears on payment of these invoices. And so that whole process would function very, very differently.
And even just clarifying, and even if the motor carrier is the agent of the responsible party, being the BCO or the consignee, they're not going to be held accountable as the responsible party. And that's one of the big shifts, is that no longer will you be approached by an equipment owner to say, we're going to shut you out for XYZ bill, even if you are handling it on behalf of the responsible party, because you're not the responsible party, right?
Correct. The rule allows any party to pay the bill, and allows the party that receives the invoice to forward it to anybody else, any other party, but motor carriers cannot be the billed party under the regulation. And so yeah, they can play a role here, but they would not be the party that is responsible. That's the way the rule's written.
For lack of a better term, I could send you my car payment bill, and if you don't pay it, they're still going to take my car, not your car, right?
That
So
is absolutely correct.
exactly. Yeah, I don't think. Do you want to pay my car lease this month? I'm just kidding.
Well, can I get your car if I don't pay it? I don't think it works that way. But it's a
Uh,
good analogy. It's a very good analogy.
yeah, I'm
That
just
works
kidding with
exactly
you.
right.
And then you mentioned the billing timeline, which obviously being more clear, and I would encourage everybody to go look at the types of data that must be included in the bill, the per diem bills, because obviously if you're missing certain elements of it, such as the start the clock date, the stop the clock date, all of those different key data elements, then obviously that's not a valid invoice either. But I think the biggest is the timing, right? Because most people followed the Uniform Intermodal Interchange Agreement, or UIIA, provisions around 60 days. Some may have had other billing in their tariff, but by and large on the equipment per diem, it was 60 days. And that after that 60 days, then a process could start. You paid the bill essentially, and then you could dispute it. Talk a little bit about what's going to have to happen, because I think the UIIA, as it relates to OSRA and D&D billing in general, has kind of been part of that discussion topic, because it's a master service agreement for the entire industry, and following the Ocean Shipping Reform Act, the trailing legislation, and now the rulemaking, there's going to have to be some significant changes to the provision of the UIIA, correct?
Yeah, I think that, yeah, certainly that's correct, and you're correct. Certainly, these bills did follow that UIA process, but it was far from as tight
Uniform?
as yeah, far from uniform. Well said, exactly. And there are multiple, often instances of motor carriers getting bills significantly after that 60-day time frame. But this is very tight, these timeframes are very tight. 30 days almost across the board for all types of disposition of these invoices, and it will be, as of May 28th, the law of the land. So you do not have the ability to negotiate different terms than those required by the law of the land. That's not the way things work. So those timeframes within the UIA will certainly have to be changed, because they are no longer applicable. It is the timeframes contained in this regulation that will have to be followed. Or as the regulation makes very clear, if you do not meet those timeframes, if you do not receive a detention and demurrage invoice bill within 30 days of the time that clock stopped, you don't have to pay it. That's the rule is very clear on that.
Yeah, and I think it's interesting because there's other provisions within the UIIA that have been at the center of discussion for at least the last 5+ years, since probably 2018. We've really seen a lot of discussion around the UIIA and the role it plays in this issue. And so I think for a lot of folks, it'll be beyond just the discussion, or the hope is that the discussion will be beyond just billing timelines, but there'll be some serious discussion as to key provisions of the agreement, especially around Section E, for instance, of the UIIA. The other big part of this that I think there's going to have to be follow up on, when you're talking about the detention and demurrage ruling, and how it pertains to the UIIA, is going to be around the dispute resolution process. Obviously, you have a different receiving party on the billing process, and it still looks at the motor carrier as the responsible party. I don't know what light you can shed into that, but obviously it's a much different situation, because in many cases, the new responsible party already has a contract directly with the equipment provider. And so, absent of the UIIA just really becoming an administrative master interchange agreement for the parties on both sides, it feels like many of the provisions are going to be misplaced. Yes or no? What are your thoughts there?
And certainly the UIIA has been a topic of conversation among motor carriers, and a source for significant heartburn for a very long time. And in our view, this will certainly require it to be reopened, as you said, I think in multiple places, not just in the 30 days. And the changes to the billing process, and who can receive these bills, I think is going to require kind of a rethinking of the way the UIIA works. I think more to come on that as well. I think we will see how all of that plays out going forward.
Yeah, and last specific question, because I know this has come up in a lot of the different motor carrier meetings I've been in, especially here in Southern California, the Harbor Trucking Association. One of the key provisions around detention and demurrage is that dispute process, providing the backup documents. Could I not get an appointment? The screenshots? Was there no available return locations? And we have seen notices from some of the equipment providers, ocean carriers mostly, but the equipment providers, that they're not going to accept certain types of backup. They could be third-party systems. There's a lot of technology development that has happened in this area. And can you talk a little bit of it? That seems like there's going to need to be clarity moving forward, because to have a very restrictive process that makes it difficult to actually provide information and data, to me, seems counterproductive to what the intent of OSRA is and the intent of the D&D billing rule, mostly because we're trying to make it more transparent and easier for folks to follow the, lack of a better word, equipment chain that happens, and when is it one party's fault versus the other. But has the IMCC started to look at, or the ATA, broader ATA, started to look at some of the restrictions that are starting to come out of the rulemaking process as to what information equipment providers will or won't accept? Because it seems to me that either there's going to have to be an agreement to be on the same page there, or there's going to have to be clarifying language in either the UIIA or some sort of trailing legislation that says you can't be restrictive on. There needs to be some sort of approved vendor list or something that doesn't make it impossible to go through these processes.
That's an interesting point, but I guess what I would say to all of that is that beyond this rulemaking, one of, I think, the strongest points of the Ocean Shipping Reform Act was to establish the charge complaint process at the FMC. And the FMC is now far more active in dealing with invoices that are deemed to be unfair or not following the requirements. And I know has already resulted in significant refunds or cancellations of bills. At least, this was, I think it was, as of 6 months ago, it was at least $1 million. I think in the first year of OSRA, which would have been June of last year. So my sense is that is not something the FMC will will accept those types of restrictions. There's all these different technologies out there, and for ocean carriers to put a particular requirement in there regarding where information needs to be located,
Or how you
my
gather it, right? The
yeah,
how.
my sense is that charge complaint, that if you take these issues to the FMC through the charge complaint process, which doesn't require much more than an email or two. It is not a major legal process. You don't have to file a major complaint with a lawyer, but you can simply send an email to the FMC. My sense is that process may push back hard on these new requirements, and that's really been, I think, one of the biggest successes from the Ocean Shipping Reform Act that we've seen, is that process is a much simpler, much more streamlined process that brings the FMC into enforcement far at a degree which they've never been before, and has made them much more aggressive in this. So I think my sense is that yes, all of those changes you outlined are probably going to happen, but the FMC will certainly have a final say on that. Whether we need additional legislation or additional regulation, I don't know, but I think we will see through the charge complaint process some of these concerns dismissed. It'd be my guess. I can't speak obviously for the FMC, but I think that's what that's the way that process has worked so far. Is they've tried to make it as simple and easy a process as possible, and if there are requirements in these bills or something that don't seem to make sense, I think they've been pushing back very hard on the ocean carriers about them.
Yeah. So what I'm hearing is if you're a responsible party and something doesn't smell right when you're told that you can't dispute something in a certain way, or you won't get accommodations for another return location or extended free time, one is reach out to either your trade association experts, folks like Jon Eisen with the IMCC. You can reach out to folks like Matt Schrapp at the HTA, or if you're part of a shipper, the John Golds at the NRF, the Peter Friedman's AgTC. I could name hundreds of people, obviously, but my point is if you're affiliated with one or several trade associations, definitely you should follow up just to bring it up as information and get their insights. And ultimately, you can check with the Federal Maritime Commission and say, this is information that I've gotten back regarding a dispute I'd like to make, or an inability to complete equipment transactions. What say ye, Federal Maritime Commission? And then allow them to educate the equipment provider on what they will and won't accept them to be able to do, creating any sort of hurdles vis-a-vis detention and demurrage billing.
Yeah, I mean, as we've said throughout this conversation, I mean, there's no question that motor carriers will continue to have to, take many of the steps that they're already taking, but they'll be working directly with their customers rather than the ocean carriers. So that information will be motor carriers will make that information available to customers to help them ensure that these bills are correct and accurate. And in terms of all those different requirements, we will see how those will stand in the end.
No, that's great. And I appreciate it, Jon. Is there anything on either one of these topics that we failed to discuss and that you'd like to bring up for the benefit of the audience? Anything that you'd like to leave them with parting words on these two topics?
Well, I think we're, as motor carriers, are certainly pleased with both of these developments. Chassis choice is important. If you are paying for the chassis, you should be able to choose your provider. It's as simple as that. And in the case of the detention demurrage invoice rule, again, making customers work together to resolve issues will be far more efficient. So in our view, these are major improvements for the supply chain that will require customers to work more closely together and hopefully increase efficiency and reduce costs for everybody. And I think that's the goal of the exercise ultimately. And what we are really working for is to create a more efficient and hopefully less expensive system to get goods all across to American consumers from overseas.
Thank you, Jon. I think next time there's been a lot of action out of the White House this year, lots of executive orders coming around. Typically, there's topics I get to discuss with your counterparts in California. But next time, maybe we have you on and talk a little bit about the Biden administration and some of the executive orders that I'm reading about every day in my ATA email communication and the great work you guys are doing. And then, obviously we'll see where this year's political cycle takes us going into next year. But it seems that this year at the ballot box, there's more on the line than just many of the issues the general public is used to, but a lot of key business issues, especially on the labor and environmental front. So look forward to tackling that in the future with you, hopefully not too distant future with you. But Jon, thank you again for joining us today. We really appreciate you, the IMCC, the entire American Trucking Association, and obviously our engagement with all of you to try to make this a better world for the motor carrier to do business in.
Well, thanks, Weston. We appreciate all the support that you and Cargomatic provide, and it was a pleasure to be here. Enjoyed this.
Thank you, Jon. That was Jon Eisen, Executive Director of the Intermodal Motor Carrier Conference of the American Trucking Association, or as I like to call him, the heavyweight advocate of the world. Thank you, Jon. For Cargomatic, this is another episode of People on the Move. I'm Weston LaBar. Until next time.